Good afternoon, everyone. Welcome to Venable's Ad Law monthly presentation. Today, we're going to be talking about legal considerations with affiliate marketing contracts. I'm going to be joined by two of my colleagues who are about to introduce themselves.
Hi, everyone. My name is Allison Lawback, and I'm an associate in the IP transactions team.
Hi, my name is Stephanie Molyneux. I'm an associate also in the IP transactions team as well as the corporate group here.
We've broken today's presentation into three pieces. First, we're going to be going over some background, both about the industry at large and the state of this contracting practice. And then we will follow up with some legal considerations that all of you might need to be aware of depending on your relevant industry or depending on your target audience. And then finally, we'll be going through a standard affiliate marketing contract. We are highlighting key terms, and we'll do our best to highlight these terms in a way that enables the typical contracting parties to see these things from each perspective. But some of the clauses we're going to profile are more relevant to one type of contracting party over another. We will not be taking questions during this presentation. However, at the end, we will make note that you can contact us with any follow-up questions that you might have.
Okay, so we'll go ahead and start with the background here about what is affiliate marketing. Now, you can tell from the name of it, it's the publisher promotes a merchant's product generally through affiliate networks. So what this means is that the merchant is actually marketing their product through an affiliate. They earn a commission based on the results, and there could be many different kinds of desired outcomes, such as a click or a purchase or anything in between, really. There's typically revenue sharing between the publisher, affiliate, merchant, advertiser, and this will all depend on the contract and the payment terms that you provide within that contract. But really, it's revenue sharing that makes this kind of model attractive. It's also passive income. It does not require the merchant to really do anything more. They've put it in the hands of the publisher and the affiliate, and they will receive that income in a passive way as well as the publisher will too. The main parties here are the merchant, the publisher or affiliate, and the customer. Now, what do each of these do? The merchant is the one that actually creates the product to be sold or makes the item or the widget or whatever it is in that scenario, but they're the ones that ultimately create the product. Then, the publisher or affiliate is the promoter of the product, and their main goal is to promote and generate more traffic to the merchant's website. So this just means that they will do their best to promote the merchant's product and get the customer back to the merchant's webpage or whatever it may be. And the customer is the end user and the purchaser of the product. Now that leads us into the traditional model because these were the main three parties when this originally first started as a marketing model. So you have the merchant at the beginning, and the merchant pays the publisher to promote the products. Then we move over to the publisher. The publisher then promotes the products to the customer. And the customer, as we said, is the end user. So the customer then visits the merchant's website and purchases the product. And that's how the money makes its way back to the merchant, and the merchant is then able to pay the publisher. Today, we find that this relationship really has changed, and there is no linear relationship between these parties. There can be, but oftentimes there is not. The lines are really blurring these days, and it's such a dynamic environment. It's also just constantly changing with respect to the roles that each party is actually undertaking. Sometimes, there are several affiliates and agents, and some of these roles can be intertwined. There are also intermediary relationships. Sometimes it's not just 1, 2, and 3. It's many people in between, and many companies and many affiliate networks. And this model has really, really grown in the past decade. Today we will focus mainly on the trends in this area as well as the big legal considerations, but we just wanted to let you know that this traditional model does not always apply, and it really is a lot more complicated. Okay, so starting off with the statistics on growth, we wanted to give you all background about really how explosive this growth has been in the past decade. Currently, affiliate marketing accounts for 15% of the total digital media advertising revenue. As you know, affiliate marketing really does take up the digital media advertising space, and 15% is huge. The U.S. affiliate marketing spending also increases by 10.1% annually, and this is constantly increasing from year to year. It's also expected to reach $6.8 billion by 2020, so that's just within the next year or the next few months. And out of all sales for advertisers, affiliate programs generate 15 to 30%. So just think of that with the whole pie. This is a big chunk of that pie. Also, more than 50% of affiliate-referred traffic comes from mobile devices, and we can easily recognize that, right, with all of the mobile use and the applications that are developed around affiliate marketing. It really is more than 50%. Also, as many of you may have guessed, the fashion industry is the most popular affiliate marketing category. Other industries do use it, and we have seen expansive growth there as well, but the fashion industry is the king here. There are also some just predicted trends overall for affiliate marketing that we wanted to highlight for your use. Of course, we just mentioned that there has been a lot of expansion into the mobile use and applications. These are the apps that are downloaded on the mobile phones. Also, we see that influencers are on different social media networks, and those have really increased in the past decade as well. Because of the increase here, though, we have also seen that they have become more heavily regulated by many different regulatory agencies. So all eyes are on the social media networks, and we expect and anticipate that more and more regulations will come out in the next few years. There are also many opportunities for expanding the market here, and the use of voice searches can be an opportunity in affiliate marketing because affiliate marketers have not yet heavily collected this data. And what this means is just that we know that we have many different things at home, that you can talk to, or that you can use a voice search on your phone just to be able to search something. But not a lot of this has really been tracked or collected. And so we identify this as an opportunity for growth as well. Another thing to consider is that if you do consider voice searches, the voice searches typically only yield the top ranked result in a search. And so that just means that you really have to be the best out there, or you have to be the #1 result to be able to get those clicks. Moving on, we wanted to talk about the incentive for both merchants and for the affiliates. For the merchants, it's really that it's a performance-based model. We talked about this just a little bit ago, talking about the desired outcome, and merchants pay for success at a time when this desired outcome has occurred. So again, this could be the click, this could be the purchase, or anything in between. Another big advantage is that it assists small businesses with limited resources to pay for advertising. And these small businesses are those merchants, the ones that are making the products to be sold. Sometimes they don't have the means to hire these massive advertising agencies, and so they will use affiliate marketing networks. It's also less time-consuming because once these merchants have these affiliate networks in place, they kind of just go forth and reap the rewards in that way. And it's really the work of the affiliate that goes on. There's also increased volume of web traffic and viewing of content for the merchants if you're doing things online, because these affiliate networks will bring in some traffic to your websites and a lot more than what you would have done on your own as a merchant. You'll also be reaching new customer bases in new regions or countries, and that's just based on the affiliates network that they already have in place or that they continue to develop with a lot of data, collection of data, and progressing how to increase the volume of that web traffic. Next, we'll discuss the incentive for affiliate marketers. It is relatively simple to enter the field. This just means that almost anyone can really start this up and it can be in many different ways. You know, we've seen influencers or endorsers, bloggers on social media networks, but they can also be more sophisticated than that and be larger companies and be affiliates and publishers. So it's also a potential steady stream of income through commission for these affiliate marketers. As we discussed earlier, it's a passive income. There's also going to be an initial cost to begin because once you start, you may not have as many channels built up, but in the future, you will develop that data as we discussed, and it eventually becomes more routine as these channels are built up. Also, one big incentive here for affiliate marketers is that they are not involved in developing the product or fulfilling the order. I mean, in a sense, they are a middleman, but they don't actually have to make sure that that order is fulfilled, worry about shipment, worry about returns, or even worry about generating the product itself. So that's all left to the merchant, and the affiliate marketer can make money just by increasing traffic to the merchant. It's pretty simple, as we've discussed, and it's not hands-on, and I think that's what makes it so attractive. And it's really become very large as an industry on its own. So we just discussed the incentives, but it's also important to consider the risks because there are specific legal risks and business risks for both the affiliates and for the merchants. Initially, starting off with the affiliates, it's very important to consider the reputation of the merchant and the quality of the merchant's product. We'll discuss this in a little bit with the legal considerations, but you have to make sure that you're not passive as an affiliate. You have to make sure that your merchant is keeping their word and doing things correctly by the law because as an affiliate, you could be held liable. Another risk to consider is that merchants may not pay their bills, and you have to consider payment schedules. And this is just, it could be a cost of doing business in kind of whatever you do, but especially in this space, it's important to consider the payment terms in the contracts. There's also an initial time investment to learn about the product and to create the traffic sources. But as we also just discussed, once these traffic sources and the channels are built up, then it becomes easier for the affiliate to keep up those traffic sources. Next, we'll discuss the risks for the merchant. So on the flip side, careful selection of the affiliate is also required because you have to make sure as the merchant that the affiliate has a good reputation in this kind of business and holds up to the success that they claim to have. So you have to make sure that they have good statistics, good analytics, and that they are able to keep up with what you want as a merchant. You also have to make sure that the affiliate is avoiding fraudulent activity. And we have also seen this in certain cases where the merchant is passive and does not watch or regulate what their affiliates are doing, and that could be a recipe for disaster as well. So part of this that's also a risk, but something to keep in mind, is the sub-affiliate relationships. So because we discussed that the linear model does not really apply anymore with all of these relationships and intermediary roles, we have to make sure that as a merchant, all of our affiliates and sub-affiliates, any other agents that work in between, will indemnify for any harm or action that happens at those levels. So we just have to make sure that when it goes up the chain, that the merchant will essentially be indemnified. Next, we'll begin to discuss legal considerations. First, we'll discuss the Fair Credit Reporting Act and the relationship to financial institutions. Then we'll talk about the FTC and state enforcement with affiliates, merchants, and affiliate network operators, because really all of them can be liable. Then we'll talk about FTC endorsements and testimonials guide. Then CanSpam, which is the privacy and security of information, and COPPA, which addresses children's privacy online. Starting off with the FCRA, this is the Fair Credit Reporting Act. There is a rule under the FCRA in the CFR that is the affiliate marketing rule. And this has been in effect since October 1, 2008, and it really does apply to a large scope of transactions. And the scope as addressed in the rule is the use of information from affiliates for the purpose of marketing solicitations or providing information to affiliates for that purpose. Also, the words eligibility information come up quite a bit in that rule, so I just wanted to start with a definition here before we get into how the rule works. Eligibility information is any information that would constitute a consumer report. In other words, a person's information from an application to determine whether the person is eligible for insurance, for example. So this does not include aggregate or blind data that does not contain personal identifiers, such as account numbers, names, or addresses. So keeping that in mind, let's get to the actual rule. The rule is that this affiliate marketing rule generally prohibits the use of that eligibility information that we just discussed about a consumer that is received from an affiliate to make a solicitation to the consumer about products or services unless these 4 requirements are met. So before I read each one, I wanted to frame this a little bit differently so that's easier to understand. Really, what this rule is saying is that if the company follows these 4 items here, then it's safe to go ahead and use the eligibility information. So the 4 requirements would be, the first one is that the consumer should be given an opt-out notice that is clear, conspicuous, concise, with accurate disclosures of the required information. Then, the consumer is provided a reasonable opportunity to opt out. The consumer must also be provided a reasonable and simple method to opt out. And we have to make sure that the consumer has not actually opted out. And what this means is that if they opt out, if the consumer elects to opt out, then any affiliate covered by the opt-out notice cannot use eligibility information received from another affiliate to make solicitations to the consumer. So really, this is just important to be aware of the ways to be able to use eligibility information. So if you follow these 4 steps, you would be safe. On the next slide, we wanted to digest this information just a little bit so that you can see the most important things to consider. Banks and financial institutions, for example, often collect data on their customers for various reasons. And that type of communication may determine whether it is covered. So, for example, a response to communication initiated by a consumer is not eligibility information. And a pre-existing business relationship is also outside of the scope. So here, what this means for banks and financial institutions is that there are a few best practices to consider. So that opt-out notice that we just discussed, you have to make sure that it is clear and conspicuous with accurate disclosures as to what's really going on with that. You also have to provide a reasonable opportunity and method for the consumer to opt out. It would also be wise to review the type of information collected and whether it falls under the definitions of eligibility information or a consumer report, because that really determines what falls under the scope of this affiliate marketing rule under the FCRA. So next, we wanted to get into enforcement with the FTC, the Federal Trade Commission. This was a big case that really made waves in this sphere. So $11.9 million was ordered by the U.S. Court of Appeals for the Second Circuit to be paid by the operator of an affiliate marketing group for its role in helping to promote Lean Spa. Lean Spa is a weight loss supplement, and they had deceptively marketed this weight loss supplement. And, you know, you can deceptively market things in many different ways. You can claim that it does something that it doesn't do, but here, what happened was that they claimed to have free trials and products with only a small shipping and handling fee. However, many consumers allegedly paid almost $80, $79.99 for this free trial, and recurring monthly shipments were difficult to cancel. So this was deceptive. This case was decided in 2015 and became the first Court of Appeals case to rule that the operator of an affiliate marketing network was liable for deception by third-party marketers. And in this case, the director of the FTC's Bureau of Consumer Protection stated that the operator of the affiliate marketing network knew its affiliates were lying to consumers and took steps to help make those lies more effective. So really what you can see here is the big lesson, the big takeaway. If you're an affiliate, publisher, or agent, you can be held liable for the merchant's products that you promote and any underlying deceptive practices. So that's what we talked about earlier. Make sure you're not passive as a merchant or as an affiliate. And now I'll hand it off to Allison to discuss FTC guidance, other legal considerations, and affiliate marketing contracts.
Awesome. Great. Thanks so much, Stephanie. So I just wanted to take a few minutes to continue talking about important FTC enforcement actions and guidelines, and then we'll segue into talking about actual affiliate marketing contracts. So the first thing I want to talk about is the guides concerning the use of endorsements and testimonials in advertising. And these are the general principles that the Commission will use in evaluating endorsements and testimonials, and they really reflect basic truth in advertising principles. While these are guidelines and not regulations, practices inconsistent with these guidelines may result in corrective action under Section 5 of the FTC Act. So under the Endorsements and Testimonials Guide, the FTC requires that material connections between an endorser and an advertiser must be clearly and conspicuously disclosed. An example of a material connection would be a connection that could affect the weight or credibility that consumers give to an endorsement. An example of this would be a business or family relationship, monetary payment, and this relates to affiliate marketing, obviously. Gifts and free products are another thing that could be considered a material connection. There is an exception if this connection is clear from the context of the communication, but the standard that the FTC will use is the reasonable consumer standard. So moving forward, the FTC doesn't have a specific language requirement on what this disclaimer must include, but they do have some guidelines, and these specify that the disclosure should be easily visible to the consumers in a reasonable font and color. The language should be easily understandable and placed in close proximity to the products and services that are being promoted. The FTC has also given specific guidance with respect to affiliate marketing, and in this guidance, they've stated that an affiliate link or buy now button generally isn't sufficient notice because the consumer might not understand simply based on this link what the relationship is between the affiliate and the merchant. This guidance that they've provided applies to all types of social media, which includes social media, and all forms and formats of advertisements, including videos, websites, and blogs. As Stephanie mentioned, ultimately your company is responsible for what others do on your behalf, and the FTC has indicated that although merchants can't be expected to know every statement or every action that's taken on behalf of their affiliates and members of their affiliate networks, merchants should have a reasonable program in place for monitoring their affiliates. And the level of this monitoring may be dependent on the risk of the product that is being advertised. And it's important to note, I know that a lot of people in the audience today are merchants, that delegating your advertising or promotional responsibilities does not necessarily relieve you of your responsibilities under the FTC Act. For those of you who are affiliates or endorsers of a product, it's important that you understand that this guidance applies anytime you endorse a product and get paid through your affiliate links. One other thing to keep in mind if you are endorsing a product is that you must be a bona fide user of the product, and your endorsement must reflect your honest opinion. You cannot make claims about a product that would require proof that you yourself don't have. For example, you cannot make claims about medical claims, or you can't make claims about medical products without substantiation. I'm going to now turn to another issue in affiliate marketing and something that all merchants and affiliates must comply with, and that's the CanSpam Act. As Stephanie mentioned with her reference to the liens law case, affiliates and merchants can be liable for their actions. And with respect to the CanSpam Act, both merchants whose products or services are being promoted, as well as the affiliates that actually send their messages, can be held legally responsible for violations of CanSpam. So merchants need to be aware of what others are doing on their behalf. Violations of CanSpam can result in up to $16,000 fines for each separate email that's sent. So when considering if you, as a merchant, will allow your affiliates to utilize emails in their marketing plans, you need to make sure that you advise your affiliates of the CanSpam Act and ensure compliance. You can do this by stating that they cannot use misleading or deceptive headers in their emails. Their subject lines must be accurate. They must identify the message as an advertisement, identify where they as the sender are located, and this must include a physical address, and they need to make it easy for recipients to opt out and honor opt-out requests promptly. Another big issue today involves compliance with COPPA. And under COPPA, there must be verifiable parental or guardian consent if a commercial website, app, or platform collects personally identifiable information from children under the age of 13, and both merchants and affiliates can be held liable. This applies even if children aren't the target demographic. The standard the FTC will use is actual knowledge. And just a few weeks ago, on September 4th, 2019, Google agreed to settle allegations by the FTC and New York Attorney General that the YouTube video sharing service illegally collected personal information from children without parental consent. The settlement here was for $170 million, and that was the largest COPPA fine to date. And as part of the settlement, Google is now making changes to its business practices.
So with that background in mind, we're going to start talking now about some of the provisions of an affiliate marketing contract. Unfortunately, we're not really able to share what would be a standard form that all of you might see. Instead, what we're going to do is break the contract down a little bit, highlight key provisions and components of the agreement that all of you might need to consider, some of the potential risks, and other issues that you might encounter related to those provisions. In this case, we want to emphasize, given the evolution of this area, that your forms are going to vary. So to some extent, you're going to be looking at this as either being on the merchant side or on the affiliate side, and consider your perspective on that traditional idea. But still, with respect to the actual contracts you're going to see, there's going to be quite a bit of variability here depending on which entity you're working with. And often now you're going to see usage of third-party affiliate networks. You're going to be leveraging advertising programs, and a number of these contracts, for better or worse, are frequently executed online and often one-sided. So notwithstanding that, there can be opportunities to perhaps edit or bring into these contracts additions, etc., modifications through order forms, but you're still going to want to read the contract. So with that in mind, we're going to go through some key contract provisions for both merchants and affiliates alike to consider.
So when you are entering into an affiliate marketing contract, whether you're entering as a merchant or an affiliate, it's important to evaluate the program guidelines. This is where the merchant will generally set forth the process for enrollment. This might include requiring an affiliate to submit an application to be an affiliate on behalf of the merchant. This is where the methods will be set forth for tracking and processing payments. This is where the merchant will identify when and how the affiliate will be paid. This can be on a pay-per-sale basis, a pay-per-click basis, or a pay-per-lead basis. And they'll set forth additional incentives that the merchant might have in addition to payment. This can include commission increases, prizes, and cash bonuses. Affiliates will also want to consider what the cookie life is, and this essentially is how long the merchant will allow before a customer, between the time when a customer clicks an affiliate link and when they actually purchase a product, in order for the affiliate to receive their commission. And merchants will want to set forth the locking period and reversal, which essentially says what happens in the event that a customer cancels an order or returns a product that was purchased through an affiliate link. As I mentioned, and as AJ mentioned, we're going to be addressing these contracts from both perspectives, but I'll also be highlighting some risk mitigation techniques that are specific to merchants. And one of the big ones here is setting forth unsuitable affiliate websites. So it's important for the merchant to identify websites that the affiliate cannot use, and these include websites that promote violence, illegal activity, sexually explicit materials, websites that promote discrimination based on race, sex, nationality, disability, sexual orientation, or age, or sites that are considered, generally in the merchant's discretion, defamatory, fraudulent, or harassing. A lot of merchants will also include language stating that the affiliate can't include affiliate links on sites that are disparaging to the merchant. Again, as a risk mitigation technique, merchants will generally want to clearly identify what affiliates can and can't say about their products. Again, an example would be that health claims must be substantiated. Stephanie highlighted a few risks for merchants, including affiliate fraud earlier. So merchants will want to clearly set forth prohibitions on the use of spyware and adware and prohibit cookie stuffing and cookie surfing, which are two common types of fraudulent affiliate behaviors. Again, the program requirements will set forth the process for an affiliate to be accepted by a merchant, and merchants will generally want to include language stating that they can reject an application for any reason in their sole discretion. They'll also want to state that the affiliate cannot provide any links to their site until they've been approved by the merchant, and the merchants will want to reserve the right to distribute email communications that are necessary for the affiliate to continue as part of the merchant's affiliate program, and they want to carve out language stating that this is the case regardless of the affiliate's choice to opt out of emails. I also mentioned earlier that disclosure requirements are very important in affiliate marketing and is something that the FTC will definitely be paying attention to. So it's important that the merchant clearly state that affiliates disclaim that they are receiving benefits in exchange for promotion. And a tip here for merchants is to require specific language. For example, as an affiliate of, insert the merchant's name here, I receive compensation for qualifying purchases. Merchants can also prohibit affiliates from claiming or otherwise suggesting that the merchant supports, sponsors, or otherwise endorses the affiliate. So as I'm sure everyone in the audience knows, representations and warranties exist in virtually any contract, and they're particularly important in affiliate marketing contracts. Generally, an affiliate marketing contract will include reps that state acceptance of the agreement and participation does not violate any laws, rules, regulations, court orders, or third-party agreements. But for merchants, it's also helpful to call out certain FTC laws. So it's important to call out that the affiliate will not violate email marketing laws, including the CanSpam Act, the endorsement and testimonial guides that I mentioned earlier, and really any guidelines used by the FTC, and specifically call out that the affiliate will not use any deceptive or misleading advertising or marketing practices. Another consideration is to include language stating that there is no threatened, pending, or ongoing claims, and that the affiliate does not require third-party consent, authorization, or approval to enter into the agreement. Sometimes affiliate marketers are on the younger side, so you want to make sure that they are the legal age to enter into the agreement, and that the customers they're referring are unique, valid, and in compliance with any qualified action criteria. You're also going to want to call out intellectual property and proprietary rights. So you want to clearly identify who owns the IP at issue and who creates the IP. Merchants want to be especially careful of the implications of the work-for-hire doctrine in California. So in California, by including work-made-for-hire language in their contracts, they might actually be creating an employer-employee relationship, which exposes the company to employer-related obligations and liabilities. Also consider the approval process for content. So if an affiliate is creating content on the merchant's behalf, the merchant will want to make sure that consider if they want to have the ability to approve the content before it is posted. They'll also want to identify the types of promotional materials that affiliates can use. So in addition to identifying the IP ownership rights, you'll also want to include an intellectual property license. This license will be drafted for the use of IP. Generally, it's going to be limited, revocable, non-exclusive, royalty-free, or fully paid up, and worldwide. You want to state expressly how the intellectual property can be used and any limitations on such use. Merchants, you might want to consider adding that the use of your IP is solely licensed to the affiliate in order to promote products and services and subject to the terms of the agreement. Affiliates, if you are allowing the merchant to use your IP, you'll want to have this expressly stated and include any prohibitions on modifications. As with any IP license, you're going to want language stating that all rights are reserved. In other words, if you are licensing IP, anything that you are not specifically licensing, or rather any rights that you're licensing, are reserved unless they're directly set forth in the contract. So as we continue talking about IP, something that's particularly important in affiliate marketing contracts is the use of trademarks. So each party is going to want to regulate the use of trademarks and clearly set forth the rules and procedures for use. So a tip for merchants is to take measures to avoid trademark poachers and fraud. This can be done by considering prohibiting the use of trademarks and variations and misspellings of trademarks in paid search campaigns, domain names, hidden text, source codes, meta tags, usernames, app names, and those types of things. The merchant can also prohibit actions that divert trademark traffic to go through affiliate links and ads first. Another big risk mitigation technique is to include regulation and audit terms in the affiliate marketing contract. As I mentioned earlier, the FTC expects merchants to be aware of the actions of their affiliates, and to mitigate these risks, merchants can expressly reserve the right to pull content and identify the consequences of failure to comply with the terms of the agreement. These consequences can include immediate termination, and the merchant can retain commissions generated through fraudulent activities. It's also important that merchants reserve the right to monitor their affiliates' actions. One practical tip is to regularly monitor and audit your affiliates' practices and create a written report of your findings. The next thing I want to touch on is privacy and data security, and once again, the tips here are specifically for merchants. Merchants should consider including language stating that affiliates cannot link to a site that does not clearly state an online privacy policy to its visitors. And merchants also might want to consider whether or not they will allow their affiliates to link to websites that are non-U.S. based and primarily serve a non-U.S. based audience. If that's the case, the merchant is going to want to require the affiliate to comply with GDPR. Relevant language that the merchant can consider including is that the affiliate, as a controller, must provide a clear privacy policy online regarding the content of the data and how it is collected and used. An opt-in option on the website regarding the data collection. They'll want to implement appropriate technical measures to ensure a level of security appropriate to the risk, be able to comply with requests from users to request and remove data, and consider the possibility of data breaches.
Some of you on the call might be asking about CCPA. For the moment, at least, that's still continuing to be resolved as to how it will ultimately be implemented. We've chosen not to comment on that, but I think as a general guide in terms of practice and some elements of CPA are at least somewhat similar to GDPR. You can look at this framework as something you can follow, but we'll be following up later in the year on CCPA-specific compliance as well.
Great. Okay, so again, the tips that we just provided were for merchants, but we have some tips for affiliates as well. If an affiliate is required to comply with specific merchant privacy requirements, affiliates should be sure to review the privacy policy in advance. And as an affiliate, you should ensure that you have the technical capabilities to comply and ultimately identify the language that allows the merchant to change the policies at any time within their sole discretion and determine if that's acceptable. So the next thing I'm going to turn to are disclaimers. Importantly, you'll want to include any disclaimers in all caps, and we recommend including language saying that disclaimers apply to the greatest extent permitted by law. We do this because some states don't allow certain disclaimers. Generally, in affiliate marketing contracts, the disclaimer will state, unless expressly stated otherwise, there are no implied warranties or express warranties related to dealing, performance, or trade usage, fitness for a particular purpose, merchantability, and occasionally there will be language about non-infringement. Merchants, you can include this. It might be a little bit risky because you want to make sure the affiliates have all the rights to use their own content, but it's something to consider. In addition, merchants can consider adding a disclaimer regarding the affiliate program and products that are being sold through it. Merchants generally don't want to promise, guarantee, or warrant an affiliate's success, income, or sales, and want to exclude warranties and representations regarding the uninterrupted or error-free functionality of the website, including potential consequences, including the consequences of referral tracking. Along with disclaimers, we'll generally see limitations of liability. Again, it's important to include them in all caps. The language typically states that there's a limitation of liability with respect to indirect, special, incidental, exemplary, punitive, or consequential damages, including without limitation loss of profits, data, or revenue. Generally, you'll want to exclude indemnification here and violation of confidentiality obligations, and include language stating that this applies whether or not it was foreseeable, and again, to the greatest extent permitted by law. As a merchant, you might want to consider whether or not to cap liability, again, excluding indemnification. A typical cap would be the aggregate of total commissions paid and fees paid in 3 months preceding the event giving rise to liability. One more merchant tip, you don't want to be liable for your affiliate's use and maintenance of their site. So as many of you know, indemnification is one of the most important provisions in any contract, and that is definitely the case in affiliate marketing contracts. Typical language states that the indemnifying party will defend, indemnify, and hold harmless the indemnified party from claims, damages, losses, liabilities, costs, and expenses, including attorney's fees. In the contract, you're going to want to clearly identify who the indemnified parties can be. We recommend including language stating that this includes the parties' employees, officers, licensors, or representatives. And generally, the indemnification provision will be for misrepresentations or any sort of breach of the reps and warranties in the contract, including violation of law, and indemnification for gross negligence or the willful misconduct of a party. So it's important to have an indemnification provision, and we also recommend setting forth the procedure for indemnification. Generally, an indemnified party must promptly notify the indemnifying party of a claim. We oftentimes include a carve-out stating that any failure or delay in providing the notice will not relieve the indemnifying party's obligations, except to the extent the party is prejudiced by such failure or delay. Generally, indemnified parties must provide reasonable assistance, but it will be at the indemnifying party's expense. And indemnifying parties will not enter into any sort of judgment or settlement that imposes any obligations or liability on the indemnified party without consent. Generally, in indemnification provisions, the indemnifying party will have the sole and exclusive control over the defense and settlement of the claim, but we do have some tips for merchants and affiliate marketing contracts. If a merchant is dealing with several small affiliates and the merchant's concerned about the ability to indemnify, the merchant can consider including the following language. They can say something along the lines of, the indemnified party has the right to participate in their own defense, and if the indemnifying party is unwilling or unable to assume the defense, as determined by the indemnified party's reasonable judgment, the indemnifying party has the right to assume the defense of their own claim. We also want to address confidentiality. Again, this is a provision that exists in most contracts and will definitely exist in affiliate marketing contracts. In a confidentiality provision, you will identify what constitutes confidential information. Oftentimes, this is sensitive business data relating to your business, customers, affiliates, associates, and collaborators, the terms of the agreement, materials that by their nature should reasonably be considered confidential. And you also want to state how the confidential information can be used. Like I indicated earlier, generally you'll want to include a prohibition on the use of confidential information to use solely to perform obligations within the scope of the agreement. There are usually exceptions that include publicly available information that is made publicly available through no fault of the receiving party, confidential information or information that was independently developed through no fault of the receiving party, and there will generally be a requirement that the receiving party be able to substantiate this. And if required by law to disclose the confidential information, the receiving party must provide notice and an opportunity for the disclosing party to take action. We're also going to talk about what to do in the event of termination of the contract, which I'm going to do in the next slide. So you're going to want to set forth what happens upon termination. Generally, the affiliate will be required to remove all links. You'll want to set forth what payment obligations exist in the event of termination, and you'll want to include language stating that confidential information should be returned, and you can either state that it will be returned or, in the alternative, state that the confidential information must be destroyed. You'll also want to include some survival language indicating that certain provisions of the contract will survive termination. Generally, these are indemnification, limitation of liability, IP and proprietary rights, governing law, and we recommend including a safeguard by stating that any section that by its nature should survive will survive. Again, this is a tip for merchants. If you are a merchant and have several affiliates or a large affiliate network, you'll generally want to include broad termination rights stating that you can terminate at any time. You'll also want to carve out the right to terminate immediately, especially in the event of fraud, and you'll want to state that no notice is required. So the following section that I'm going to go over deals with modification of contracts, and this is particularly important in the case of contracts of adhesion. So if a merchant has a large affiliate network and uses a lot of affiliates, AJ mentioned earlier that the terms might simply be posted online. You'll want to set forth how the contract can be modified and how the affiliates will be provided notice. You can indicate that an updated contract will be posted, consider whether or not you will email your affiliates, and then set forth what constitutes acceptance in the event that the terms are changed. This can include continued participation in the agreement, and you can also consider requiring written consent. If you are a merchant and this is a contract of adhesion, you can also include language stating that you can modify the agreement at any time in your sole discretion. But if you do this, we recommend putting the language in all caps and in bold to ensure that the affiliate has notice of this provision. So the last contract term that I'm going to be discussing relates to the relationship of the parties and assignment. So you want to set forth language stating that the merchant and affiliate are independent contractors and make it clear that there is no employment relationship. As a merchant, you want to clarify that your customers are not the affiliate's customers. Generally, in any contract, there will be an assignment provision stating whether or not the contract can be assigned. As a merchant, we generally recommend allowing an affiliate to assign this contract because you are contracting for the affiliate themselves and you have specifically vetted each affiliate.
Thank you all for joining us today. We covered a lot of ground, but hopefully you've got a better sense of these type of contracts and the background for them. If you do have any follow-up questions, you can reach us at the email set forth here at the first slide of the presentation. But also, if you look to your invitation, there's a contact email address that can get routed to us to address any follow-up you have. Thank you for joining us.